I want to thank everybody for being here today. The Committee on Homeland Security and Public Safety and Veterans Affairs will now come to order. The clerk will call the roll.
Chairman Hefner,
Here.
Vice Chair Lopez,
Here.
Canales, Cortez, Isaac, Durazio,
Here.
Lauterbach, McLaughlin,
Here.
Holt,
Here.
Pearson, Hickland.
A quorum is present. As a reminder, anyone wishing to testify before the committee, please register at the kiosks located in the hallways behind the hearing rooms. If you need assistance in registering or testifying, please contact, let me know or my staff know, and we'll get you some assistance there. I'm probably a little bit long. In order to ensure that everyone has an opportunity to be heard today, public testimony will be limited to 3 minutes each. Do any of the members of the committee have any, y'all have any questions or anything before we get going? All right. Laying out my own bill, right? All right, the chair lays out Senate Bill 15 by Senator King. What you looking for? That's right. All right. All right, thank you, members, for hearing my bill today. Appreciate y'all being here on a Friday morning in a special session in August. Certain information related to a peace officer should be open to the public, and certain information should not be disclosed to the public. Unsubstantiated complaints of peace officer misconduct, in particular, should not be released to the public. Right now, there is no consistency among law enforcement agencies regarding what files are made public and what files are not made public. Civil service cities, which are those that have adopted Chapter 143 of the Local Government Code, currently maintain both a separate personnel file and a department file for every officer. Some of those cities that had the 143 adoption are cities like Tyler, Lubbock, Fort Worth, and Amarillo, and other cities around the state. Around 26,000 peace officers total operate under provisions of this bill currently. Chapter 143 requires the following documents to be held in the personnel file: substantiated misconduct complaints, which are those resulting in disciplinary action, accommodations, congratulations, or an award bestowed on the officer, and periodic evaluations of the officer by a supervisor. All other documents not required to be held in a peace officer's personnel file must be held in their department file. This file would include unsubstantiated misconduct complaints against an officer, coaching documents, and background hiring information. Other law enforcement agencies would still have access to this file for the hiring purposes. In response to a recommendation by the Sunset Commission, Cole commissioners adopted a model personnel department file policy for all law enforcement agencies that substantively mirrors the requirements of Chapter 143 for civil service cities. Senate Bill 17 codifies this model policy to prevent any conflict with current law. I do want to stress that Senate Bill 15 not only that it only affects requests for disclosure under the Public Information Act. If someone is suing a law enforcement agency or officer, they will still have access to the documents in the department file via discovery as required by law. This is true for a prosecuting attorney attempting to access files to press criminal charges against an officer, defense counsel, and other policy agencies. Additionally, this bill will not affect disclosure requirements under the Michael Morton Act and the Sandra Bland Act. Senator King accepted an amendment on the Senate floor that clarifies for purposes of accountability and transparency of those specific acts. Members, the reason for this bill is to make sure that we maintain transparency, but that we don't weaponize this department file in cases to discredit our officers. That is something that we're seeing around the state. These things that should not be used to discredit them are being used. And so we want to protect the integrity and transparency of the process, but also help our law enforcement officers do their job. So with that, I'm happy to answer any questions. Show Representative Pearson present. Chair recognizes Representative Pearson.
Thank you, Chairman. Only have one question. As of right now, does this include all police departments, or are there any police departments that are not included?
It would include all police departments,
Okay.
all agencies across the state.
Okay, thank you.
Chair recognizes Representative DeRazio.
Thank you, Mr. Chairman. I have two questions. Question number one, would the passage of this bill in any way prevent the release of video footage, either from body cams or security cameras, when it comes to investigations?
No, this bill doesn't affect the body cam process at all. That is policed and managed in its own section of code. We're not touching that.
Okay, thank you. And question two, would the passage of this bill change anything relating to internal investigations of small law enforcement agencies?
No, sir.
Thank you,
It
Mr.
would not.
Chairman.
Do you have a question?
I just wanted to clarify, thank you, Mr. Chairman. It's not just police departments, it's also sheriff's departments,
Correct.
any law enforcement
Yes.
agency. Okay, thank you.
I think you've
Correct.
answered my question. I mean, my deal is you know, being, was a mayor of U-Valley during the Robb School deal. We're 3.5 years. You saw yesterday the school district didn't release all the information they had. I want to protect our officers, and I see the intent of this bill. I just want to make sure that files like that aren't used, or this law isn't used to hide those files. I mean, I still think we need answers to that day.
Right, and this bill would not affect those cases in any way. And so that's a legal process, and there's a process working its way through there that this would not affect in any way.
Thank you.
All right, if there's no other questions, we'll proceed to testimony. Chair calls Sarah Beck. Sarah Beck, B-E-C-K. Okay, we have Sarah Beck registered, testifying on behalf of herself against the bill, but not testifying. Chair calls, is it Lakshmi Fox? I apologize if I didn't get that pronunciation right. Did I pronounce it right?
Lakshmi? It's close enough.
Lakshmi? So you registered as Lakshmi Fox, testifying on behalf of yourself
Yes,
and against the bill, is that correct?
that is correct.
All righty, please proceed.
Good morning, members of the committee. Thank you for your time. My name is Lakshmi Fox. I am here to oppose SB 15 as it fails small agencies and hides misconduct. SB 15 would require all law enforcement agencies, even those with just one officer, to maintain a confidential department file that includes misconduct allegations. While this sounds like accountability, it actually enables secrecy, especially in Texas' smallest departments. According to TCOL, 44.4 of agencies, that's 1,227 total, have 5 or fewer peace officers. 542 of those agencies have only 1 officer, and 331 of those are elected constables. This bill would force single officer agencies to file and seal misconduct records about themselves with no oversight. The key problems with SB 15 is, one of them is self-surveillance. One-person agencies would be responsible for documenting and sealing complaints against themselves, and there's no meaningful accountability in that. This would also shield elected officials. Constables and sheriffs could bury their own misconduct in confidential files. Without any amendments, even public integrity investigators or jail standards officials cannot access these records. Blocks transparency and oversight. Civilian oversight boards and other agencies would be shut out. Instead of exposing misconduct, SB 15 helps hide it. It silences whistleblowers. In small departments, reporting a colleague or a boss is already risky. Knowing the report will be sealed and controlled by the accused only discourages speaking up. The bottom line is that SB 15 creates a system that protects bad actors, especially in the 44.4 departments that are too small to self-police. It sacrifices transparency and public trust in the very places where oversight is the weakest. Please oppose SB 15. It doesn't fix the problem. It hides it. Thank you.
Thank you, members. Any questions for this witness? All right, thank you for being here. We appreciate your testimony.
Thank you.
Chair calls C.J. Grisham. I have you registered as C.J. Grisham, testifying on behalf of yourself and against the bill. Is that correct?
That is correct, yes, Mr.
Okay,
Chair.
go ahead.
And hello to my awesome Representative Hicklin. You represent us well, ma'am. My name is C.J. Grisham. I'm here in opposition to SB 15 on my own behalf because as a civil rights attorney at the website isuebadcops.com, SB 15 is perhaps one of the most dangerous bills I've seen since I began coming to the Capitol. SB 15 should be named the Protect Bad Cops and Let the People Eat Cake Act. I feel like this body needs to be reminded that Article 1, Section 2 of our Constitution says that all political power is inherent in the people and that all governments are founded on their authority and instituted for their benefit, not the benefit of protecting bad cops, the people's benefit. Mr. Chairman is correct. There is currently no consistency regarding law enforcement records. That's because some departments believe in transparency and some don't. Unfortunately, most don't, in my experience. It's that we investigated ourselves and found no wrongdoing mentality. SB 15 creates a department file where any file maintained by a law enforcement agency is protected from release that includes findings of no misconduct. Here's the issue that I have. Because, Mr. Chair, you correctly laid out the bill and said that I can get this information through discovery, right? But guess what that means? That means that someone who's been wronged, before they file a lawsuit, they're not going to know whether they have standing or not. And they're going to have to hire and pay an attorney to get information that they should be able to just get. A good police officer isn't afraid of having unfounded complaints released. It actually makes them look good that they've got unfounded complaints. A bad police officer does care, and I'll tell you why, because there's something called Monell liability, and I don't know how many people here are attorneys, but in order for me to sue under Monell liability, I have to be able to prove a practice, policy, or procedure that a city or an entity has in place that caused or supported or facilitated that officer's or that public official's behavior. I can't do that. If I can't go and I'm getting ready to file my lawsuit, but what I do my due process, because I'm a retired federal agent. I'm in law enforcement. I'm retired law enforcement. There's my T-Cole card, there's my retired law enforcement card, there's my old badge, my retired badge. It means nothing. It's just a retired badge. So I don't hate cops. I do hate bad cops. With a passion, I hate bad cops. And I represent a lot of good cops. The problem here is when I go to file a case against a law enforcement officer, I'm like, ooh, I get to sue another cop. I do my due diligence first. I file an open records request. I try to find out what information can I have. Has that officer been accused of the same thing before? Because if a police department is saying unfounded, which is what is happening in the cases that I'm filing, and then I file my civil lawsuit, and I find out that the city has actually let this guy off previously and said, oh, there was no misconduct, and yet I get my clients a nice, healthy paycheck because he is doing that. And it just so happens that my client was able to afford an attorney. This is a bad bill. It protects bad cops. I ask you to vote against it.
So you think that any individual out here in the public can just file unlimited, unsubstantiated, unfounded complaints?
No,
And that
oh,
you
sorry.
don't believe that that's going to be used against these cops when they go to court on other cases?
Well, it sounds like the
That
problem
attorneys
is
will not exploit that?
yeah, it sounds like that the problem is malicious complaining and filing of false reports. Why don't we go after the people filing false reports? That's the problem. But is that a possibility that people are going to maliciously file these complaints? Look, I know for a fact, even if it's a legitimate arrest, because I have people come to me all the time. They're like, "Hey, I was arrested, but they didn't read my Miranda rights, so my rights were violated. I want to sue." Right? Sorry, can't do that. Your rights weren't violated. And I understand that there are a lot of people who just don't understand how police work works. And so they think their rights are being violated. They file a complaint. And guess what? That complaint's going to be unsubstantiated. Now, if it's done maliciously, I think that there are ways that both law enforcement and the legislature's already put in place about filing false official reports. You can get them for retaliation. I mean, there's all kinds of things that we can go after. But what we're doing is we're saying, you, the public, because there are some people out there that file frivolous lawsuits, you, the public, don't deserve to know that this officer's been accused of this before. And, you know, it's not until the fourth or fifth time, or sometimes maybe just the second time, that the officer gets caught. And we need to know how many times, as attorneys and as plaintiffs, how many times did the city allow this to happen? Because am I just going to sue the officer, or am I going to sue the city who keeps condoning this behavior by finding that behavior perfectly legitimate and the officer did no wrongdoing? So that's the problem that I see from our angle. I think the best way to fix it, because I know everyone's asking, well, what would you do to fix this bill? Like, how could I support this bill? Very simple. Add something in there that allows for a third party, not the police department itself, not the internal affairs, nobody associated with that, some third party, whether it's a committee of citizens, that they look at the complaints. And that committee of citizens needs to include law enforcement, because they're going to have to explain law enforcement strategies and tactics and all that, because, again, let's say the complaint is he didn't read me my Miranda rights. Well, that's because he didn't interrogate you and you weren't in custody. Didn't have to. You know, you'd have a police officer or several police officers on this committee. So I think that what needs to be fixed is, if anything, I think this bill's trash. It just needs to go away because it protects bad cops. But if you're asking me, CJ, how can we fix it? Make police complaints subject to third-party review. And I don't mean another just law enforcement agency, because they're going to protect each other. I'm talking about some kind of a committee or agency or something.
So you think other cops are just going to protect bad cops?
I see it every day. I don't think, I know.
Well, I don't think that. I think the vast majority of cops are good, and that they are like you and they despise bad cops. My brother's a law enforcement officer. But anybody got any other questions?
Well, just yesterday, Judge, sorry, I'm used to being in court. Mr. Chair, I mean, yesterday I had 2 cops come to me through a third party because they were afraid to talk to me, because they wanted to go after bad cops and what their supervisors were ordering them to do. I know there are good cops out there, and I want to protect them. What I don't want to do is protect the bad ones, and that's what this does, because it's just a blanket, oh, it was unfounded. But how do we know this isn't a pattern or practice?
Okay. Chair recognizes Representative Hicklin.
Thank you. Mr. Grisham, so in the scenario that you presented of, going to see a history of unfounded complaints that then might together look different, why would that not be provided through discovery? Like, could you not get those records and discovery of a case?
That's a great question. And as I said at the beginning, yes, I can. But that's me as an attorney. They're having to hire me, and now they're having to pay me to draft all these documents, to get all this discovery, to go through discovery, then explain the discovery, whereas they can just pay me to do an open records request and do all that. Like I said I mentioned this in the Senate, that there are many departments out there, and they're usually the smaller departments, out in West and East Texas that I've dealt with, where I go to a department and I say, hey, I've got a client that said they filed a complete police report or a complaint against this officer, and it sounds like a legitimate complaint. Can I get the record of that? Oh, well, we dropped it because he retired or he resigned. And so a lot of these departments, not the big cities, because I know, I think Dallas was in here testifying in the Senate bill last month. I think it was SB 14 last month. that they have a process that it doesn't matter if the officer leaves or retires or quits or whatever, they still complete the investigation. The reality is, a lot of these smaller departments don't. When they give that officer a chance, you can leave or we're gonna investigate you. Well, guess what? Now I don't even get to see that because it just gets stopped, or in other words, unfounded. And this is reality. I'm not making this stuff up. These are the cases that I personally take where they're dropping investigations and not even going through with them because the officer would prefer, oh crap, I'm in trouble, so I'm just gonna quit. And then he moves on to the next department to become a problem.
Thank
Or
you.
she, excuse me.
Thank you.
I need to show Representative Louderback present.
And that's the best sheriff in Texas right there, too.
Chair recognizes Representative McLaughlin.
So first of all, I agree with you, we need to be transparent and so forth. But secondly, though, just like you said, there's bad cops out there, there's bad lawyers that use this to taint an officer that shouldn't be tainted. So they go and get a complaint that an officer has had unsubstantiated claims or they don't prove to be there. But that lawyer doesn't paint it that way. He paints this guy as a villain, and they've ruined that guy's life before he gets there. And once the genie's out of the box, there's no putting it out of the bottle. There's no putting it back in the bottle to justify this deal. We do need to be transparent, but at the same token, if we go after that person for filing that malicious or false claim, then we're here again. It comes back. It's going to be tainted that the officers are going after this individual because he stood up, and that's the problem that we have. And I saw it over and over and over since Uvalde, and in other instances, there are officers that did try to do the right thing, and there are officers that didn't. They're constantly crucified for what they did, and that's not right. I mean, these people put their lives on the line for us every day, and I'm all about transparency, and we should be. And if there's a serious incident, we need to be transparent on it. But at the same token, we have to protect these guys to some degree.
And I'm going to agree with you. I'm going to blow your mind, Representative. Most attorneys suck. I'll just say that. As an attorney. That's why I became an attorney late in life, because it's about money. It's not about justice. It's not about doing the right thing. And sometimes just because you're paid to make a cop look bad, you shouldn't be doing that. Or even just because you're paid to make a defendant look bad, you shouldn't be doing that. What I will say is, and I wish all attorneys were the way that I carry myself and why I decided to become an attorney late in life with ethics. I don't sue any cop that I haven't completely investigated, and I make sure that that guy is a bad apple and needs to be sued. But the cases that I take because no other attorney will take them. These are cases of small infractions. A guy thrown into a police car for 7 minutes for no reason, just because the cop didn't like him, right? And no attorney is going to take that, because what's 7 minutes in a police car? Even though your rights are violated, your First Amendment and your Fourth Amendment rights are violated, they had no reason to toss you into that police car. No attorney is going to take a case where I was only stuck in a police car for 7 minutes. That's what I do. Or I can't afford to have a good attorney. That's what I do, because my job is to get rid of the bad cops, because that takes care of the good cops. When the bad ones are getting the good ones hurt. And so my job is to weed that out. But this bill makes it harder for me to weed out those bad cops because it protects them. And I'm literally on their side. I'm your best friend if you're a good cop, but I am your worst enemy if you're violating people's rights.
Chair recognizes Representative Louderback.
Hey, CJ.
Sheriff, how are you? Or Representative, which do you prefer?
They both work.
All right.
So we've known each other quite some time, have we not?
Yes, sir.
So I think what this bill is trying to do is simply extend the same protections that civil service has already, and it will actually benefit the sheriff's world immensely. And your comment about the industry not able to police itself or not wanting to police itself is simply wrong. We simply, I have never, in many of my cohorts, we're valiantly trying to clean the industry up at all times, and it's difficult. It's a challenge. There's 2,800 agencies in this state, so it's a huge number. We're faced with systemic losses of personnel constantly, but it doesn't mean that a sheriff or police chief doesn't know exactly what's going on. And so these protections that we're asking for in this bill are simply already present in our state. Already certain numbers of law enforcement have this protection. So what we're simply saying is we want to extend it and make it consistent everywhere. Does that make sense?
It does, and I'll tell you that my opposition to this bill is hypocritical as an attorney, because For example, and I talk about this openly, I'm on probation, a probationary status. I have been since I became an attorney 3 years ago. It doesn't stop me from doing anything, and the reasoning isn't because I do something wrong in the courtroom, it's my mouth. But
I can
if-
understand that.
Yes, if someone comes in and wants to say, hey, why is CJ on probation? Guess what? Those records are protected. Now, I don't care. I'll show them to them. I'll give them everything they want to see. That's me personally, because I believe in transparency. But, you know, I'm protected by the same law that this bill, or the same sort of rules that this bill would bring in. But I would actually support a bill that reverses it for attorneys. All the bar complaints I've had, they're all unsubstantiated. I would love for everybody to see those because of how stupid and, I apologize for using that word, but, you know, how obnoxious the complaints are. And I know law enforcement goes through the same thing. So I get it, and I do speak from a position of hypocrisy because I'm currently protected. But anybody that wants to see my disciplinary records, I'll gladly turn them over. I just want transparency on any public official, and I know I'm not a public official, but attorneys do the public's work. So, but yes, I agree with you, Sheriff. I understand this is difficult. That's why I think that instead of just defeating it, and I would hope that you could admit that there are departments out there that do protect bad cops. They're not many, but there are institutions out there, and it's really in these smaller departments where everybody's buddy-buddy with each other. And these smaller counties even. I don't even think I know of a bad sheriff's department. So the sheriffs I don't even have complaints usually against. But it's these smaller departments, and that's where I think this bill is really doing harm. And I think a separate committee or a third party that includes law enforcement on this committee, and it can even be in a majority law enforcement, that's who investigates wrongdoing, not the agency itself. I mean, you know, if someone, really quick and I'll shut up. You know, I had someone ask me on Twitter, I need to know who your supervisor is. So I gave him my cell phone number because I work for myself. So they called me and they said, hey, CJ's doing this, 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 and this, and this. And I said, oh, that's terrible, but do you have a problem? Let me look into it. Yeah, he's good. You know, and I investigated myself and found that that person's complaint against me to my supervisor, who was me, was unfounded. So.
T-Cope plays a role in this too, but thank you for your testimony.
Yes, sir. Thank you.
Chair recognizes Representative DeRicio.
Appreciate you coming and testifying. And, you know, we definitely want transparency in the process. And we definitely want justice to be done. But I'm also in favor of protecting the rights of the police officer until a thorough investigation is done.
Amen.
And then one of the things that you said in the testimony was about supervisors squelching a police officer or letting him know that, you know, he's being investigated, and the police officer quits on his own fruition, using pressure to have him resign his position. Whenever we had a dispute on a transaction, and it was between two powerful opponents, you know, to put something like this to a committee and the community and things of that nature, our citizenry is very astute from what I've seen, and they vote right every time. But in matters of legal, police affairs, and, you know, what some bad actor in the public is trying to do to a police officer and undermine the integrity of an individual because they're angry at him for giving him a ticket or something he justly deserved, and then to open up these records in order to accuse him, you know, I have a hard time with that. But on some of these disputes that we have to deal with, my team would have to choose, on something like this, our team would choose a police chief or a police officer from a completely different district, and the other police officer would choose, or whoever they were, whatever department it was, they would choose another individual from a completely other district. Those two people that were chosen, they would come together and they would choose a district or a police officer to investigate. Why aren't we doing something like that here?
Well, I think we could. I will admit I'm probably a little bit cynical because of the kinds of cases that I take. But, you know, the good thing is what this bill will do is make me more money. because now people will, instead of just paying me $250 to write a open records request and going over the records that way, they're going to have to hire me for a full-on case. I don't want to disparage the entire system, because as Sheriff Louderback, as Representative Louderback said, and also the chair, most police officers are good cops. But what this does is it protects that minority of bad cops that affect the most people. I mean, they're the ones that not only get their fellow cops killed, but citizens on the side of the road, or in a parking lot, but also their fellow officers, because the bad officers create resentment in the public. And that resentment translates to bad opinions towards law enforcement. Then you've automatically got that, when they come together, the head beating, and then so the officer, the bad officer, will do something worse to make it worse, and then you get more resentment. It's this vicious cycle. And I think the best infectant to that is just transparency. And while I would benefit from this bill passing as an attorney, because if I don't have access to those records, the only thing I can do is sue to find out if there's a case. I just don't think that's good public policy that, well, we're going to pass this, and you know what, if you don't like it, just hire an attorney, just sue, and you'll get it in discovery. Our courts are so backed up as it is. Now we've got to go through all that. It takes a lot of money and time to write a complaint and to do the investigation and get the discovery. Discovery is the worst part of any case. So that's all I'll say to that. That's all I'll say to that, I guess.
I appreciate it. Thank
Yes,
you.
sir.
All right, members, any other questions? All righty. Thank you for your testimony.
Thank you, Mr. Chair.
Chair calls Peter Hunt. Have you registered as Peter Hunt, testifying on behalf of yourself and against the bill? Is that correct?
Yes, Chair, that's correct.
All righty, please proceed.
Thank you. My name is Peter Hunt. I'm testifying against the bill, representing myself, and I wanted to bring up some concerns related to some unintended consequences with the text of the bill as it stands. Now, on the Senate floor last week, there was some conflicting conversation about what exactly would be covered and what could be overruled here, and so I wanted to address that. I'll do what I can to cover it in the time available, and I'm happy to take any questions. The first part I wanted to talk about was this issue of body-worn camera footage. Now, the text of the bill as it stands looks like it would prevent the authorized disclosure of body-worn camera footage. This is because the bill itself says that a department file maintained under this section is subject to disclosure only as required by law, and then lists a couple other laws that have to do with body-worn camera footage. And though that language referencing these other sections of the Texas Code was put in by the Senate to try to address this issue. Now, body-worn camera footage is often proactively disclosed by chiefs of police in response to these complaints, and this gets precisely to the testimony that was just given, that if there's a complaint brought against an officer and the department wants to address that and say, no, that complaint was illegitimate, let's clarify why, in a way that establishes transparency, builds trust, and actually helps resolve this issue of unfounded complaints being used against officers, that would be prohibited by the bill text as it stands, just on paper, whether or not that's the intent. And this is because the section of the language that refers to the disclosure of body-worn camera footage only authorizes disclosures. It does not require them. And as I said, the law says disclosure only as required by law, which means that optional proactive disclosure by a department would still be prohibited, even if the intent is to do otherwise, is to allow those disclosures. So the bill, I believe, should be amended, at the very least, if this is going to be an issue, to respond to that by allowing not only required by law disclosures, but any authorized by law. So that's, I think, the first unintended consequence of the text as it stands, just going back to what's on the page to bring up. The second has King said that his intention in response to some questions on the Senate floor was that meet and confer agreements as they currently stand should be able to supersede parts of this law, so that those agreements that have already been put in place can continue forward on the terms that were mutually agreeable at the time. Unfortunately, it does not seem that this is clear. I've elaborated on this with various members of y'all's staff earlier this week, but it's not clear that meet and confer agreements actually can supersede state law, especially parts of the operations code where this would be located. And there are good reasons for that, and It seems like the only way to resolve that, if this bill is passed out with its current text, would basically be through a lot of case-by-case litigation. My time is up, but I'm happy to take any further questions.
Members, any questions for this witness? Okay, we thank you. Thank you for your testimony. Chair calls Mary Elizabeth. I show you registered as Mary M. Elizabeth,
Yes.
testifying on behalf of yourself and the Austin Justice Coalition and against the bill. Is that correct?
That's correct.
All righty, please proceed.
I'm speaking about serious emotional trauma resulting from police shootings and the need for families to have access to all law enforcement records of the incident. Although the Uvalde shooting on May 22nd, 2022 was not a police shooting, the lack of law enforcement action that day was just as devastating to the families and children of Robb Elementary School. The extreme level of trauma they experienced is diagnosed as post-traumatic stress disorder, or PTSD. The law enforcement officers who were present then undoubtedly are affected by this as well. PTSD disrupts lives and shatters families. It manifests in a myriad of disabling emotional and behavioral problems ranging from panic attacks to suicide. The children at Robb in 2022 are growing up. Their normal developmental progress toward adulthood is significantly challenged and might be delayed. It will affect how they parent their own children and will limit their life prospects. As one Uvalde father verbalized his own trauma, it's just really hard because I know how my children were before the shooting. The families need to know in order to process all of what happened and not be left with unanswered questions that intrude in their lives every single day. The records provide vital information that they can't get anywhere else. Without knowing the reality of what happened, instead of healing, they will be left with a disturbing emotional weight they will carry for the rest of their lives. Additionally, these families and the entire community can no longer depend on their law enforcement agencies and state government to protect them. These agencies will only regain respect when they are accountable and transparent about these murders. Thank you.
Thank you, members. Any questions for this witness? All righty, thank you for being here. We appreciate your testimony. Chair calls James Songer. I show you registered as James Songer, testifying on behalf of Dallas Police Department
Yes, sir.
and yourself, and for the bill.
Yes, sir.
All righty, please proceed.
Yes, sir. Good morning, Chair and committee members. My name is Lieutenant James Songer, and I now represent the Dallas Police Department. The Dallas Police Department is in support of Senate Bill 15 as an opportunity to make some specific reports confidential. Automatically generated reports related to officer performance and its attendance provide a good starting point when addressing an officer's productivity. We would like to utilize these reports as part of an early warning system, but we are not a Chapter 143 civil service agency. We're a municipal civil service agency. As a result, reports related to an early warning system, including performance improvement plans, will be subject to release even before their accuracy is verified. Additionally, reports related to an officer's use of sick leave, vacation leave, and when they choose to take their holiday are subject to release and are not currently confidential. And an officer's performance or attendance rises to a level of misconduct through violations of policy or law, then it becomes a matter of public concern and our department has no issue with releasing that information. Until such scenario, we would like to keep attendance and performance-related reports confidential. Thank you for the opportunity to speak in support of this bill and on behalf of the Dallas Police Department, as this bill provides us with an avenue to be a responsible employer by developing our staff and implementing a robust early warning system.
So when you're talking about the attendance record of someone being put in their file and being subject to public before you can even
Yes, sir,
verify
correct.
if it's
And,
accurate.
a
that
real
could be-
example.
That is
Oh,
something
sorry.
that could be irrelevant to a case being brought that a lawyer could use to, he could exploit that to discredit an officer.
Correct, yes, sir. And another good example that we did have happen was we had an estranged husband, ex-husband, do an open records request on his wife, and there were some family violence issues going in there to figure out when she was taken off and making sure he was around while she was off. So we believe that would protect the officer in their personal life also, making that confidential.
Okay, so some of these records can be used against these officers in their private lives even?
Yes, sir,
Okay.
correct.
Chair recognizes Representative McLaughlin.
So the question that I have is gonna go back to a mass casualty incident like the Robb School shooting or so forth. Do you support, or would this bill, in your opinion, shield those officers from review of their conduct on that day and releasing the information of that day?
Not at all, sir. I don't believe this bill would affect that at all. I mean, the amendment that was added in the Senate says, as required by law, that requirement would already, I mean, we already know that's gonna be by law anyways. And as far as a body-worn camera, that's a complete own statute. So also, those videos would be governed underneath a different statute than what this bill would do. So, yes, sir, I believe those would be subject, not maybe to open records, but definitely to the legality part of it. It would be presented in public.
Okay, well, I mean, that's the problem we have, I think, in some of these instances that we have now. And I'm gonna harp on Rob, and I hate to use that
Sure.
as a deal, but we're 3.5 years there, and we still have videos that aren't released. We still have departments that haven't released reports. And for me, if this bill is gonna go into codify that, where you can do that, then I would be a no on it.
This bill does not even, because you're talking about video specifically, this bill does not touch on videos. This bill is departmental documents that we're utilizing. That body-worn camera and the dash cam videos, that's all underneath a separate statute. So no, this bill would not affect that.
Okay, well, I mean, some of it is not just the video, there's even code of conduct that's not
Right.
being released at this time, which, to me, from that day, we're all big boys, we made mistakes, whatever, we need to lay our cards on the table and deal with
Completely
it.
agree with you, sir. That was a horrible incident. I completely agree that I do not believe this bill would affect making those records public.
Okay, thank you.
That's what I believe.
Chair recognizes Representative Holt.
Thank you for being here today. I just want to clarify, so about the body camera, the footage and all of that. So that footage does not follow a particular officer? Is that what you're saying? It's in a different setup? Explain that for me.
There's state law already regarding body-worn camera. There's a separate body-worn camera statute and code of criminal procedure that the police departments have to follow. And the only person that's really authorized, unless it's legal, is always handed over to the attorneys and stuff. But the chief of police has to authorize the release of those already. That's nothing to do with this bill.
Okay.
So there's a statute that governs body-worn camera and dash cam also.
Okay,
So
so-
that's not really related to this bill.
So body cam footage could not be buried in a file somewhere and protected that way?
No,
with
no,
this
ma'am,
bill?
I do not believe it would.
Okay.
It could be or would be. I mean, our body-worn camera is loaded to a cloud, evidence.com. Now, we do make copies of that, but it's just a copy of what the actual video is.
Okay.
So no, ma'am, I do not believe this bill would affect that at all.
Okay, thank you.
Chair recognizes Representative Louderback.
Thanks for your service, Lieutenant. Let's be real clear here, just so the committee knows. Any investigation that a law enforcement officer has, if he resigns from that agency, doesn't that follow him?
Yes, sir. So not only that, but because of the sunset bill, they put in place last session, any pending investigation, even if officer quits, the department is required by TCO to complete that investigation.
Thank you.
And that will stay in their file that is subject to any other police department that's going to be hiring that officer. They can get that file and review that also.
Appreciate
Even the unsustained complaints would be reviewable by that hiring agency.
Thank you.
Chair recognizes Vice Chair Lopez.
Thank you, Chairman. Yeah, thanks for being here to testify. there was an issue that was raised that certainly, resonates with me, and I would love to get your opinion on it, that this applies to all departments across the state, regardless of size. And it's really difficult sometimes to craft something that is one size fits all. What are your thoughts about that? I mean, obviously, Dallas, San Antonio, Houston, Austin, all those are large departments. How about the small ones, which there's a large amount of? How would you square that with the
So-
small ones?
I'm really only supposed to give testimony on what my department does.
Sure.
But I would say that in that scenario that CJ was bringing up, in all honesty, if a citizen calls a small department to complain on them, there may not be paperwork to begin with anyways, because if they're going to cover up for their officers, they're just going to tell the citizen, oh, we'll take care of it and hang up the phone. So that's already going to be an issue without this bill. They're just going to not take the complaint. And I imagine some small departments probably, hey, we'll talk to that officer, we'll take care of it, and we'll investigate it, but maybe just word of mouth, hey, don't do that again. That's not really something that's gonna follow them, right? So I would imagine that if that's happening at a small police department, it's gonna continue to happen if this bill is passed or not.
And we may have some witnesses later
Okay.
that cover some small agencies that can get down to that in a granular.
Okay, great, I appreciate it,
But
thank
like
you.
the one-man police departments, I mean, the mayor would be, from my experience, the mayor would probably be responsible for investigating that small of a police department in a citizen complaint.
Thank you.
Members, any other questions? All righty. Thank you for being here.
Thank you,
Appreciate you.
appreciate it.
Chair calls Robin Kirschenbaum. Did I pronounce that correctly? Yes, you did. Awesome, okay. I show you registered as Robin Kirschenbaum, testifying on behalf of yourself and against the bill. Is that correct?
Yes.
All righty,
thank you.
proceed.
Chairman and committee members, thank you for hearing my testimony. I feel that jails require a separate analysis of the documents that will be closed. Bexar County Jail has just returned to supervision after a scandal involving guards who let gang members into cells to beat them over failure to repay small loans. These beatings had been going on for at least a few months. No jailers had been disciplined. Had someone not died during an independent Sandra Bland investigation, those beatings would still be going on probably. Harris County Jail has been subject to many inmate complaints about being punched in the head unreasonably by guards. None has resulted in discipline, and it was not clear the complaints were being investigated. Eventually, a news organization asked for video, got that video of hundreds of incidents, and published its findings in December of last year. Then, the sheriff announced that some of the beatings were against policy and began to issue discipline and consider policy changes. Tarrant County Jail, after the death of a local gun rights activist, Mason Yancey, is still under fire for its substantially higher than average rates of deaths in custody and the death of a baby who was not counted as a person. The sheriff has been failing to bring in outside investigators and instead conducting internal investigations, getting the Fort Worth PD to rubber stamp them and sending them to those files to the Commission on Jail Standards. During this past regular session, the commission announced that the practices were non-compliant and has clarified what a Sandra Bland investigation requires. Representatives from the Texas Jail Project in Houston came to this building during the regular session to give you a better picture of the extent to which inmate complaints are not investigated. Misconduct is allowed to fester in a culture of impunity, and the extent of the work that will be needed to improve oversight and accountability. This bill will do the opposite of that. There has not been due consideration to the special duties to the voters and the public when it comes to the conditions of pretrial incarcerations, which is what the vast majority of inmates are serving. If you continue down this path, I ask that you exclude jails and jailers from the scope of the bill and make sure a full public vetting occurs before documents, now public, documents that have revealed both problems and have launched jails on a path to better conditions becomes confidential by law. Thank you.
Members, any questions? All righty, thank you for your testimony.
Thank you.
Chair calls Kathy Mitchell. I show you registered as Kathy Mitchell, testifying on behalf of Equity Action and yourself and against the
sir.
bill. Is that correct?
Yes, sir.
All right,
Thank you.
proceed with your testimony.
Thank you all. I think that a sign that this is not ready for prime time is the degree to which we are all coming up here to try and figure out what it means. Court's job is to harmonize competing laws. This bill very clearly says that any document relating to a license holder becomes confidential. We've had a number of people explain that that is personnel documents, or that is documents related to algorithms that are going to go into a red flag system. To be honest, every time I hear testimony, I understand better what documents proponents actually want to make confidential, and that is incredibly useful. I think that there is a path to an agreed bill here, a largely agreed bill. But this bill is not it. Because right now, and I want to lean in a little bit to the debate, let's call it, over body camera footage. The body camera footage law is a standalone law that authorizes, it does not require release. That release is very useful to police departments for building trust between police and communities. And sometimes it just rips the Band-Aid off things that need to be released. That law has two sections. The first authorizes release in the event that a chief determines it's in the interest of law enforcement, and that's that flexibility piece. And the other authorizes release unless there is authorizes release, but allows agencies to use all the exceptions to disclosure that are in the Public Information Act. One of those exceptions to disclosure, of course, is the 101 exception, things made confidential by law. This bill creates a confidential by law law. I will guarantee you that this law will send all of the discussion about Uvalde and other cases back to square one legally, because a judge is going to have to harmonize the intent of this law with the intent of the law that says everything is, you can release it unless it's confidential under one of the exceptions to Public Information Act, and the first exception is 552.101. Now, that is just a narrow analysis of one law and one situation. When you say you are making any document confidential if it relates to a license holder, you are going to throw into disarray many laws that have been working more or less just fine up until now. I think that the back and forth that we've seen over this bill, over the application of Michael Morton, and the need to have some kind of clear pipeline that addresses the Michael Morton Act and the possibility that defendants are not getting the information they're constitutionally required to get in criminal cases, is an example of how hard it is to do this when you start with the framework that everything is secret unless, and then here are the exceptions that apply. So I just want to say, I think this bill still needs work, and I think an interim study where we actually lay out the documents that have been of concern, the abuses that we're seeing in the real world, and try and build a system that addresses the abuses. To your point, sir, a system where there's any kind of external review would be an improvement in many of those smaller jurisdictions than what we have now.
Members, any questions? All right, Ms. Mitchell, thank you for your testimony. Chair calls Paige Williams. I show you registered as Paige Williams, testifying on behalf of the Dallas County District Attorney's Office.
Yes.
Is that correct? And you're neutral on the bill?
Yes.
Okay. Go ahead.
Again, my name is Paige Williams. I'm here representing Dallas County Criminal District Attorney John Crusoe, and we are neutral on the bill, primarily because we support the policy behind this. And I want to make sure that everybody understands what we're trying to do here, is we're trying to thread that needle where police officers and subsequently our criminal cases are not being tried in the court of public opinion before we can actually take care of them. And part of doing that, the way that this is crafted, is that we are moving to letting all law enforcement agencies have a department file and a personnel file. And to be clear, the things that will go into the departmental file are unsubstantiated claims. The reason that we are neutral on the bill is because we do believe that there should be a carve-out for district attorneys' offices specifically for criminal cases across the board, because there is another policy issue at play that hasn't been discussed, and that is going to be balancing the labor rights of a police officer with the constitutional rights of a defendant. That is something that I definitely want y'all to think about. But again, we are neutral on the bill, and we discussed this with Senator King, and that is why he made the change to unless otherwise provided by law in his bill. So we definitely believe that we are moving in the right direction, and we can live with the language that is there. And I'm happy to answer any questions, but to answer some of the questions that have already been asked, in regards to small law enforcement agencies, I was a former rural elected DA, and I can tell you in a small agency, if anything happened, the whole community knew about it. It was already public. Officer transfers and whether or not their personnel information transfers, y'all covered that in the 88th. Gypsy Cop bill was done in the 87th. So those protections for misconduct officers have already been put in place in law. And again, the change that Senator King made encompasses all of that. So with that.
Members, any questions? Representative Pearson.
Thank you, Chairman. Thank you for being here. Could you just go a little bit further with what you were speaking about for DAs specifically? What exact language are you thinking we might need here?
So currently in the bill, and I believe y'all did this, it was the 87th that did this, there's a carve out for other law enforcement agencies that they can have access to everything when an officer transfers. And under the new model policies under TCOL that y'all did under the sunset last session, if they can't leave an agency under, dubious circumstances, because that investigation will have to finish and go with them if they try to change law enforcement agencies. And so as far as DAs go, we would like to also just be included in that carve out, because at the end of the day, every county does it differently. Like Harris County, we know, does protective orders for the department file. Austin, I believe, I just learned, also does protective orders for the department file. We don't in Dallas. And ultimately, when those are negotiated, they're negotiated pre-trial. And it's our position in Dallas is that pre-trial, a judge, one, a defense attorney is not required to tell you why that information is relevant, because they don't have to tell you their case. And two, we might not know as prosecutors if that department file is relevant to anything in the case. So if you just open it up so that we can see all of it, then you have a criminal attorney as opposed to a civil attorney who is usually arguing these labor issues. You'll have a criminal attorney looking at it and saying, hey, this does fall under Michael Morton, this does fall under Brady, this does, and we'll have to turn it over. Because from a criminal standpoint, unlike the bad officer case, what we have is we have defendants who have, like one officer could handle thousands of cases in their career. So one bad act or one unsubstantiated act that might be relevant to a defendant might be relevant to thousands of defendants. And what we don't want is the Michael Morton case 25 years later, where a police officer found something that wasn't relevant, turned out that it was the linchpin to the case. So that's why we would still advocate for a carve-out. I understand that, that's a bigger discussion, which is why we are on the bill, because we understand right now the court of public opinion versus the sanctity of our cases is at risk here. So,
Okay, thank you very much.
you're welcome.
All right, members, any other questions? All righty, thank you for your testimony.
Thank you.
Chair calls Justin West. Have you registered as Justin West, testifying on behalf of Galveston County Precinct 4 and yourself, and for the bill, is that correct?
Yes, that's correct.
All righty, proceed with your testimony.
Thank you, Mr. Chairman, Vice Chair, members of the committee. I'm Constable Justin West from Galveston County. I have an agency of between 9 and 12, depending on how many reserves I have at the point in time. One thing I want to address, and I'm going to reiterate what she said and a couple others, is TCOL, after Sunset, has put together policies. There's already been a addressing for the wandering officer. The investigations that have to be completed regardless of employment status, the removal of the F5 classifications. So a lot of times in the past, agencies say, well, if you'll just resign, we'll give you a good F5. Now that's gone. We have to complete investigations. And within 90 days, those have to be uploaded to TCOL. So it doesn't matter if they left or not, they're still going to be investigated. That is required. So if an agency isn't doing that, so the one-man agencies still have to be investigated. And the idea of investigating yourself is not proper law enforcement. So to believe that investigating yourself is going to happen, it shouldn't. If it does, that needs to be addressed some other way. So the saying goes, where there's smoke, there's fire, right? So when you have an officer who deals with the same violators regularly and the violators just get tired of being dealt with, they start filing complaints. Something even more simple than that is a traffic stop where someone didn't want to get a ticket. Well, now you're going to get a complaint because, oh, that officer was mean to me or didn't take into account that I was sick or whatever the case might be. We still have to investigate those because they're sworn complaints. So if we're going to have all that out there, now it's going to become this large movement of the social media and I heard the Court of Criminal or the Court of Social Justice and online opinion and all those things. That's going to become the way people are going to move. They're going to start going out and making these complaints because they know they can affect the officer's career, maybe their family life, maybe they're staying in the community. So we need to protect our officers in that regard. The point of what our attorney said earlier is he wants to be able to see everything because it becomes a subpoena instead of a public information request. Well, if we go down the road of just releasing everything, there's already officers protected by this, so now we're not being fair. The committee that built this policy that this legislation is based on was civilians, it was law enforcement officers, it was statewide, it was people from rural environments, it was people from the urban environments. They met for 6 solid months everywhere in the regions in the state. So everyone had an opportunity to give opinion on this when it was being drafted, and that's why it came out the way it did. Labor groups were involved, again, law enforcement, defense attorneys, prosecutors, everybody was at the table for this. So the legislation is simply codifying what was put into that policy. And what we are actually operating under that policy right now. We're just asking for you to report favorably to the floor and for it to finally pass and codify that language for us. And I'm available for questions if you have any.
All right, members, any questions? All right, Constable, thank you for your
Thank you so
testimony.
much.
We appreciate you being here. Chair calls Jim Crosby. I have you registered as Jim Crosby, testifying on behalf of yourself and against the bill. Is that correct?
That's correct,
All
thanks.
right, proceed with your testimony.
I want to address briefly 3 issues raised by the bill: use of force reports, complaints filed, and separation reports and separation data. But because I tend to go long, I want to start with my conclusions, if you'll bear with me. The list of documents goes well beyond those 3 issues, and reports of public interest with respect to a police agency or jail, much longer. And yes, they are in many different files. I would ask that you consider conducting an interim study that actually examines the information, now subject to Public Information Act requests, and sometimes actually given to reporters and the public, whether the release of such documents is in the public interest and whether the interest of the officer can be addressed in some less harmful way than sealing the records altogether. I would also ask that you look at the various exceptions that already apply and whether they already address any concerns officers may have. So first, use of force reports. The most important case that currently defines what is and is not secret in Chapter 143 cities is San Antonio versus San Antonio Express News, in which courts determined that when an officer fills out a use of force report after using force, that report is not personnel information. Courts have said this is not personnel data. That analysis would be superseded by this new analysis. Does it relate to the officer, and is it one of the listed, quote, public documents? The answers are clearly yes and no, so it would be sealed. The downside is a significant loss of public transparency and confidence around one of the most often raised issues with policing. In most cases, the data and the reports are used to evaluate the conduct of entire units and the larger force, or conduct by sector. This can be done without the name of the individual officers. The reporting almost universally shows that force incidents involving injury are rare, but sometimes it also points to certain units that need retraining or may need some staff to be rotated out. And taken together with the next item, complaints, it can help community groups have better and more informed conversations with department leadership. So cutting to the chase now, complaints filed. A complaint filed against an officer is, quote, personnel information and could still be protected by this bill under language that narrows the confidentiality to personnel information. A complaint filed with an agency in which the name of the officer and any identifying information has been redacted is not personnel information. Under a narrower version of the bill limited to personnel information, complaints could be made available in a redacted form. And I'll go ahead in my last few seconds to deal briefly with separation reports and separation data. Similar to complaints, separation reports and the exit information reported by separating officers are personnel information and are also important for public accountability when agencies are struggling with retention. Separation reports are personnel information and could be made confidential in a narrower personnel file system. Thank you.
Members, any questions for this witness? All right, Mr. Crosby, thank you for being here.
Thank you.
Chair calls Robin Foster. I have you registered as Robin Foster, testifying on behalf of the Harris County Deputies Organization and neutral on the bill. Is that correct?
That is correct. I
right.
also have handouts, but without the clerk.
We can do it.
Thank you.
All righty, go ahead and proceed with your testimony.
Good morning, Chairman Hefner and members. Thank you for the opportunity to speak with you. My name is Robin Foster, and I represent Harris County Deputies Organization Fraternal Order Police Lodge 39. I am also joined in these comments by the Texas Municipal Police Association, the Houston Police Officers Union, and the Austin Police Association, and the Dallas Police Association. I am providing a handout to the members today that outline the legal aspects of our position, and I can answer any questions regarding that. In simple terms, we would like to make the committee aware of what we see as lack of protections for confidential and sensitive information that is going to be mandated held indefinitely in these department files. This includes personal medical information of the officer, leave information, and unsubstantiated complaints. What I mean by complaints against the officer, that is after an investigation has occurred and no policy violation was determined, those are unsubstantiated complaints, meaning the officer has been found innocent of the allegations. This proposed language does not seek to curb Michael Morton Act or Sandra Bland Act. We fully support those requirements. What we are asking is that a judge make a determination in camera what shall be disclosed and an automatic protective order be put on those documents. The process outlined here is similar to that given to officers in agencies with specific meet and confer agreements under 143, such as the Houston Police Department. 143 allows for contracts to protect safeguards of employees. We are asking is that these same safeguards be given to all officers and jailers in order to protect their personal information, as well as the information this bill makes confidential. So the purpose of this bill is to keep things confidential. We're just asking for a protective order on these things when they get disclosed through the Michael Morton Act, in order to keep it within the case at hand and not become a media circus. Thank you for your time and consideration in this matter.
Thank you for your testimony. Members, any questions for this witness? All righty. Thank you for being here.
Thank you so much.
Chair calls Elizabeth Miller. I show you registered as Elizabeth Miller, testifying on behalf of yourself and against the bill. Is that correct?
That's correct, and
All
I
right.
have some
Proceed with your
sheets for
testimony.
y'all.
Yeah.
If I may. Thank you, and good morning. My name is Elizabeth Miller. I'm here testifying on my own behalf. I am also a policy director for Republican Liberty Caucus, and I have a lot of concerns about this bill, too many to get into here, but I wanted to let everybody know that I suspect many of them are similar to the ones that Senator Hall has. He's opposed to this bill. Campaign for Liberty is also opposed to this bill. I don't have enough for the whole class, I apologize, but I do have here a couple of copies of a bill analysis from Texas Policy Research, and their job is to, they look to defend, all of these organizations look to defend individual rights and limit government, and are concerned about the incentives that we're building in here that could increase corruption, the risk of corruption, the risk to transparency. But you've heard about some of those today, and again, we don't have time, so I want to incorporate some of those concerns. I must say, though, I'm an old civil trial lawyer. I've been plaintiff in defense. I represented the nation's largest retailer for a number of years in what was probably thousands of cases. And I respectfully disagree with some of the representations about how a court will interpret some of this. Shall means shall. Confidential means confidential. Documents in civil litigation means everything, real or digital, that contains information. Now, then we debate about relevance and things like that, but documents is almost everything in the law. So I respectfully disagree to some of the representations about how this will be interpreted by a court. This is aggravated by the fact that this is a new law since those other laws. Just because you say except provided by law doesn't mean that the other law trumps. It just means it's there. This one says confidential and all persons. That's very broad. And I think you've heard enough concerns here today that it's safe to say this is just not fully baked. I understand the concerns. I want to go after them. But some of the reasons that you will find in the piece from Texas Policy Research about their concerns have to do with some of what you've heard, and that is defending the actions of a good cop and good policing. My brain goes there because, again, I represented the nation's largest retailer. So in incidents that happen in the store, so I'm sort of defending the associates, so the analogy, that's where I go. How am I going to show that a good cop or a good associate or a good manager did the right thing if I don't have the documents? I need the reports that they say, oh, that associate walked by that spill a dozen times. I need what the law considers documents, essentially everything, to show that they did the right thing. So I have a lot of concerns. I urge you to please wait. Republican Liberty Caucus urges you to take the interim to really think this through a little better, and I welcome questions. Thank you.
Members, any questions? All righty. Thank you for being here. Thank you
Thank
for your
you.
testimony. Chair calls Wendy Tippett. I show you registered as Wendy Tippett, testifying on behalf of yourself and against the bill. Is that correct?
Yes, sir.
All righty, proceed with your
I have
testimony.
some handouts as well. Good morning. My name is Wendy Tippett, and I stand before you today not just as a citizen, but as a mother whose life was forever changed. On September 14th, 2022, my son, Timothy Michael Randall, was killed by Rusk County Sheriff's deputy during what should have been a routine traffic stop. In less than 2 minutes from being pulled over, my son's life was taken. He was 29 years old, unarmed, and less than an eighth of a mile from his home. As devastating as that was, what followed was another kind of cruelty. It took me 2.5 years, over 900 days, in a federal lawsuit just to gain access to the dash cam footage of the incident. 2.5 years of silence, 2.5 years of stonewalling, 2.5 years of torturing myself with every possible scenario I could think of that would make it make sense to me because my son was a kind and respectful young man. 2.5 years of not knowing the truth about what happened to my own child. I'm here today because no family should ever have to fight this hard just to know the truth. Just to know the truth. Transparency is not optional. It is the very foundation of trust between law enforcement and the communities they serve. When evidence is withheld, trust in law enforcement and government collapses. When families are silenced, when the public is kept in the dark, the damage extends far beyond one case. It erodes faith in every officer, every department, and in the justice system itself. Justice cannot survive in secrecy. I stand before you today to say that we can and we must do better. True justice cannot exist without truth, and truth cannot exist without transparency. I'm asking you as lawmakers to take action. Mandatory required release of body and dash cam footage in cases involving serious injury or death within a reasonable time frame. Timely access for families, and ensure families have timely access to reports, evidence, and belongings of their loved ones. Independent investigation. All misconduct cases must be investigated and tried by an outside independent agency, not by the same agency for department involved. These steps are not anti-police, they're not pro-accountability, they are pro-accountability, pro-community, and pro-justice. Good officers deserve to work in the system that is trusted, and families deserve honesty, and every life deserves dignity, even in death. My son deserved better, the people of this state deserve better, and you as lawmakers have the power to ensure that no mother has to stand before you begging for the truth. Michael's life mattered, his story matters, and what happened to him must mean something. Let his memory be a reason why we commit right here and now to transparency, accountability, and change. Thank you.
Members, any questions for this witness? All righty, Ms. Tippett, thank you for your testimony. Chair calls Alicia Castillo. Show you registered as Alicia Castillo, testifying on behalf of the Texas Civil Rights Project and against the bill. Is that correct? All righty. Proceed with your testimony.
That's correct. Alicia Castillo, representing the Texas Civil Rights Project. And the first thing I want to mention is that there was a lot of talk about misconduct during this hearing, and I wish that this was really a legitimate conversation about just misconduct, but it's so much more than that because the language of the bill before you says that what will be concealed going forward if this bill passes is all letter, memoranda, or documents related to a license holder, including records of unsubstantiated misconduct, not limited to, including. all records related, all documents. And so what I've handed out before you today is a legal memo from our legal team at Texas Civil Rights Project that does interpret, as many folks here today have interpreted documents and related to mean everything. That interpretation is actually shared by Senator King, who said on the floor during the floor debate that all documents means everything. So that was Senator King's read of the bill. Perhaps there's a disagreement from this chamber, but we have concerns with including every document related to a license holder in a confidential file. Another thing that I'll mention, I know this has been talked about before, we discussed the tragedy in Uvalde that families are still dealing with to this day. The section of the Code of Criminal Procedure that talks about body-worn camera footage is Article 2B.0112. That is where the code talks about exempting release on discretion of the agency. So despite the noble effort of amendments from members on the other chamber to protect some of these things, it doesn't actually do that because, again, the code that it references in this bill goes back and says that the release of that footage is discretionary according to the agency. But also in this bill, it wouldn't exclude documents like 911 call logs and audio. It wouldn't include security camera footage. In fact, today, families in Uvalde are still battling in the courts over gathering security camera footage from what happened that day because DPS is currently in custody of that, and DPS is fighting the release of that footage. Another thing I'll mention is that this independent investigations thing, I understand that some members of this committee might feel that officers are infallible and wouldn't cover for one another. But unfortunately, the TCOL model policy rule, that's 2.1 under the misconduct policy, this is mirrored in the occupations code under 1701.001 that misconduct is that which may result in a suspension, demotion, or termination. That's misconduct. And additionally, what TCOL says must be done to initiate an investigation, it just says an appropriate investigation must be done to substantiate or unsubstantiate misconduct. That is not a high enough standard for us to feel like unsubstantiated claims are false complaints. So I can share, I have more points if there are any questions, but respectfully, thank you for your time.
All righty, members, any questions for this witness? Representative Pearson.
Thank you. Thank you for being here and testifying. You said that an appropriate is not really valid because there's no definition. What would you define as an appropriate investigation?
Well, I would recommend, you've heard a lot of conflicting testimony today, that this be a broader discussion. And then I would mirror the request of some other witnesses that this be an interim study because appropriate to one person might mean something and might mean something else to another person. But at the bare minimum, a uniform standard for independent investigations is really important. And I think many people have said that today, independent. I heard one deputy say that, well, in smaller agencies, the mayor will do it. Okay, if that's true, then maybe we should put that in TCOL model policy that some independent body will do that investigation.
So is your concern with that piece of it just that it's just too vague?
That's part of my concern. Appropriate administrative or criminal investigation is ultimately going to be determined by the law enforcement agency. So in this case of small departments or perhaps a sheriff in a jail, if it's a very small agency, appropriate. If there is no requirement for them to contract with some outside agency or body, appropriate might just mean that I've looked into myself and found complaints to be unsubstantiated.
Okay, thank you.
Thank you.
All right, Representative McLaughlin.
So my understanding of the intent of this bill is to seal unsubstantiated claims to be used against an officer, as I said earlier with the attorney earlier, is just like he alludes to bad cops, you allude to bad attorneys that use unsubstantiated claims to paint a picture of a villain. That's usually not the case. But you're saying this goes beyond that and seals everything, not just the substantiated claims?
Yes, sir. That's exactly my read because it says all letter, memoranda, documents related to a license holder, including those related to unsubstantiated complaints, not limited to.
Isn't there already law enforcement agencies out there today that are already using this and protected by this today, a good portion?
Well, there is the G file, right? We have about 70 cities who are civil service cities, and they get the G file, this secret file held by the department that contains records like these. The G file has a lot more listed about what goes into the G file than this bill does. There is no list, to my knowledge, and it could have changed before.
Well, you keep saying that it says all documents, but this says.
Any, I'm sorry.
Well, it doesn't say that either. It says any letter, memorandum, or document relating to the license holder not included in a personnel file. So there
Right.
are other files and other things that are disclosed to the public that are stored in the personnel file.
And the personnel
So
file.
not everything goes in the department file. So that's a misrepresentation of what this bill is talking about. There are things that are disclosed to the public that go into the personnel file. And then there are things that are not disclosed to the public that go into the department file. And those things are letters, memorandums, unsubstantiated claims, and the things that we've talked about all day. So
Yes,
let's make
sir.
sure we
And
keep
in the
that clear.
Occupations Code, Chapter 1701, we get a list of what's in the personnel file. And that includes commendations of the officer, that includes some supervisory notes and other things related to misconduct.
Yeah.
And that's it.
No,
That's in
not
the personal.
coaching and
The coaching,
maybe
yes.
correcting the officer.
Supervisory notes, yes, sir.
I wouldn't say that's related to misconduct.
Sure,
That
okay.
If it
Well,
rises to misconduct, I think it's going to go into a different file, would be my understanding, so.
And I would understand it that way too if the bill was limited to misconduct and it didn't say including unsubstantiated misconduct, but was more specific about those types of documents. And while we would still not be in favor of that, because again, unsubstantiated does not mean false, that would really clarify, I think, for a lot of the people that have some confusion about this bill, while again, the stated intent being to protect officers from unsubstantiated complaints being made public. That's not my read of it, and the personnel file is incredibly limited. So I could, I think you probably have that code near you, Occupations Code 1701, that outlines what that list is. But what is public in the personnel file is not going to include all of these other things that I've mentioned: 911 call logs, audio, security camera footage, body-worn camera footage, and critical incidents.
Their
The
health
list could go
history,
on.
their days off and things, so that people can't nitpick their personal lives also.
Yes, sir, and that's why SB 1569 from this regular session was so important, because Senator King acknowledged that releasing sensitive personnel information is not appropriate. So that bill allows a redaction of personally identifiable information, but that bill goes into effect in about 2 weeks here. And so one other recommendation would be allowing us to implement that bill, redact personally identifiable information from our public servants, and then take a look and see if we still have this problem that officers are concerned with about their information being released, because I believe Senator King's bill, SB 1569, should protect for cases like that once implemented.
Okay. Any other questions, members? All righty. Thank you for your testimony.
Thank you.
Chair calls Chris Harris. Show you registered as Chris Harris, testifying on behalf of the Texas Civil Rights Project against the bill. Is that right?
Yes, that's correct. And
Proceed.
Thank you so much for the time. And I'll just follow up on my colleague's testimony here. The point about the personnel file is well taken. There are three main things in the personnel file that would be excluded from this department file, which would be largely confidential in perpetuity. As was mentioned, those include honors, commendations of the officer, sustained misconduct, information from the agency about sustained misconduct would be in the personnel file, and that could be released. And then you have the regular, review of the officer, a note about their regular review. So those three things. It was also mentioned in previous testimony, court cases that have found that things like use of force reports would not go into personnel files. So what that leaves in the department file is everything else. So everything that's not a commendation, the sort of regular review of the officer, and the sustained complaints leading to that the suspension, termination, firing. Those are the things are going to be put into this, under the current language of the bill, into this department file and ultimately be confidential in perpetuity from almost everybody. And so, and again, to the point, this is not just unsubstantiated complaints. And again, we also have an issue with what that means, because again, it doesn't mean false, because we don't always have an investigation that actually occurs with related to those. And again, especially if the issue is not something that under TCO could rise to the level of necessitating a suspension or a termination if found to be substantiated. So we have an entire world of things that may not result in an investigation, may not ever be subject to disclosure, that would get thrown into this pot under the notion that these are false complaints that would be harmful to an officer. But in actuality, could include things like use of force reports, could include things like incident reports, could include things potentially like body cams, based on some of the interpretation that you've heard here today, despite the recent amendment to the bill. Could include, obviously, and then the issue at hand, which is the actual complaints that could or could not be valid, but for whatever reason, maybe because of the size of the agency, their ability to undertake an investigation, the lack of ability to find a third party to conduct an investigation, or a simple unwillingness on the part of the agency leadership because the incident was embarrassing to them personally, and they don't want to substantiate it and make it part of the personnel file that then could become public. These are all issues where, you know, this bill is potentially creating a very wide net of secrecy that would include the things like the Uvalde case. And I think what you're getting a picture of is people are saying that this could lead to harms to officers, the current situation. But what you're hearing is actual harms visited upon actual families today by the status quo, and a bill that, instead of addressing the issues that families are facing and getting access to the information about what's happened to their loved ones, we're getting a bill that takes us back in the other direction and just implements more secrecy on top of the secrecy that honestly already pervades too much of the policing. Thank you.
Members, any questions? All righty. Thank you for your testimony.
Thank you.
Chair calls Kirsten Budwine. Did I say that right?
Yes, sir.
Okay, I show you registered as Kirsten Budwine, testifying on behalf of Texas Civil Rights Project and yourself and against the bill.
Yes, sir.
All right, proceed with your
And
testimony.
because I'm the third person to come up here from TCRP, I'm not going to rehash anything that's been said already. But as an attorney, I was really concerned with the conversation that y'all were having with Mr. Grisham earlier about who would and would not have access to these documents. I find it really troubling to set a precedent that someone would have to hire an attorney to sue whoever has these documents in order for them to get access to it. As you've already heard from several witnesses, these documents are already extremely difficult to get under the PIA, the Public Information Act law, and I just find it really troubling. I had to come up here and say that as an attorney. I just find it really concerning that that's kind of where we're starting, and that's the precedent that we will be setting with this bill. And so that's what I want to limit my testimony to.
All righty.
Thank you.
Members, any questions? All righty. Thank you for your testimony. Chair calls Brian McGivern. How bad did I butcher that?
Well, I knew you were talking to me.
Okay. Okay. How do you pronounce it?
McGivern.
McGivern. So you registered as Brian McGivern, testifying on behalf of yourself and neutral on the bill?
Yes.
All righty. Proceed.
So I decided to come here because I wanted to share a concern that I have with that the bill as it's drafted now, I think threatens to undermine some carefully crafted agreements that have been executed between municipal police associations and their municipality. I guess I should introduce myself. I'm an attorney. I'm the executive director of a group called the Austin Community Law Center. And over the last 9 years, I've had many reasons or many opportunities or many instances where I've reviewed the scope of Local Government Code 143, including .089G, but not exclusively. And I think that everyone can probably agree that there's at least some tension between the language in the proposed bill and 143. It says, the current bill says as provided by law, or as required by law, I think. And the language in 143 that permits these agreements, these collective bargaining agreements, to disclose information, it simply says that an agreement will preempt contrary state law. It doesn't specifically say anything about disclosing information from the G file. This creates some ambiguity. Now, as a practitioner, I contemplate, how would a judge look at this? Well, Government Code 311, the Code Construction Act, sets forth many principles for how to try to reconcile two statutes, because of course that's the goal, to try to make them both effective. Two of the principles in there, one which alarms me the most, is that when there is a conflict and you can't reconcile two statutes, the statute later in time prevails. One that gives me a little bit less heartburn, but is still concerning, is the principle that the more specific language, the more specific section of the code prevails over a general rule. Now, I understand, reasonable minds can differ on the interpretation. Members of this committee have, I'm sure, formed their own beliefs about how these two statutes would reconcile with each other, or how they should be. But I also think you shouldn't lose sight of the fact that there are 15 courts of appeals in this state and a whole mess of district court judges, any of whom could very well read this differently. And I understand that there are statements of intent within the legislative history, but I also know that in interpreting the law, the word of the law prevails first. Only in a moment where they cannot determine to their satisfaction, the meaning of the written words, will they look to parole evidence like statements in legislative history, which only have marginal benefit because one person may intend one thing, but who's to say that that is what every person voting on this within the legislature believed? And so, because of that, the way it is written, I do think that it threatens to undermine some of these agreements, both for officer access to additional information that they wouldn't necessarily have when they are subject to discipline, and to access by civilian review entities. So,
Thank you for your testimony. Members, any questions for this witness? Thank you for being here.
thank you for your time.
Chair calls Skylar Hearn. We show you registered as Skylar Hearn, testifying on behalf of the Sheriff's Association of Texas and for the bill. Is that correct?
That is correct.
All righty, proceed with your testimony.
Mr. Chairman, Vice Chair, members, on behalf of the Sheriff's Association, we are asking for your support for this bill. This is not a new concept. For more than 20 years, the state legislature has provided statutory coverage to certain municipal police officers and all DPS officers, these same provisions, preventing public access to unsubstantiated complaints. That's about 26,000 officers around the state that currently have this coverage. Missing from that statutory coverage is every sheriff's office. Every county that y'all represent, there's not one deputy or one jailer that has that same coverage. That's 17,000 deputies, 25,000 jailers that would like the fairness of having what has already been the concept for more than 2 decades. A lot's been said, and I know your time is precious, so I will open myself up for questions if you have them. But for your deputies and your jailers in your counties, we ask for your support for this bill.
All righty. The chair recognizes Representative Louderback.
Scott, I appreciate you testifying today and bringing some clarity to a situation that seems to be, I guess, collectively misconstrued with some misinformation for some time. So in the deputy world, the jailer world, and in certain small cities and things, have we been looking for some consistency in this? And with consistency, doesn't that bring with it a degree of credibility that has been missing for the deputy and the jailer world in small city police departments or civil service. Aren't we trying to get to a point where we all have the same system that we're working under? Isn't that the best idea that we could have as far as policy?
Yes, I agree. And I think through y'all's help, we have done that over several sessions. One of the biggest things that y'all helped with was the sunset bill in the 88th session for TCOL, that prior to that bill, there was a loophole. An agency didn't have to complete an investigation. In fact, some agencies, chief administrators would bargain a resignation over a completed investigation, so somebody would just go away that was a problem. And as an administrator and a 32-year officer, we don't want bad officers either, right? So that fixed the issue of the gypsy cop and the wandering officer, and requires administrators to ensure that if there's any allegation of misconduct, I can't bargain that into a resignation, and if the officer decides to leave anyway, I still have to finish that investigation, so that any other agency that wants to hire that person knows everything that person's done, and there's some closure to that. And those incremental steps have got us to this point where it's only natural to make sure that everybody's working off the same coverage for when those same investigations determine them to be unsubstantiated. We should all have the same coverage statewide.
Thank you. Thank you for your years of service with the Department of Public Safety as a director, and thank you for your work with the sheriffs.
Representative McLaughlin.
First and foremost, thank you for your service, and I do support law enforcement, but I have to go 2 questions. One, so if we pass this bill, would TCO still be entitled to look at these files as
100%, yes, sir.
they license that officer?
Yes, sir.
And the second deal to that question would be, again, I got to go back to the Robb School shooting and so forth. In an incident like that, it's to your best interest as a law enforcement to lay the cards on the table for that day. Because until we get those answers, you still have a black eye in the public's eye.
Yes. Again, I think there's been lots of coulds and mights and mays applied to what people think this might be versus what it is. This does not affect criminal investigations or accusations of criminal misconduct or any of the associated work product of the agency that goes with that. Videos, case reports, all of that is covered under all kind of other locations. This is about the individual officer's document. This is not about the body-worn camera. This is not about the case report. This is not about the call logs from dispatch. All of that is governed separately and is held and maintained separately under different statutes.
Okay, thank you.
The only other thing I'd add, Mr. Chairman, is there's been several comments about independent investigation. That would be wholly untenable in the state of Texas, that somebody else has to investigate every complaint that comes in for 2,700 agencies. You would have to create 2,700 new agencies just to work complaints for all of that. It would just
2,700
be untenable.
times at least 3 to 5 to 7 people, whatever that committee would look like.
Yeah, it would be an untenable situation. It sounds good when you say it, having independent review, but with the volume of, again, unfortunately, a lot of people out there get their legal advice from TikTok and Instagram. And they think they know their rights, and the bulk of those are just misinformed. They think they're right, but they're misinformed, and it spawns all these complaints of, you didn't do this, and you didn't do that, or you did this, and you shouldn't have. And the vast majority of those are just unfounded and misinformed. And it would take a whole new agency to do an independent review of every complaint.
Okay. Representative Holt, then I'll come back to you.
Thank you for being here, and thank you for your service. I just have a real quick question. Approximately how many complaints are frivolous or unfounded?
Based on statistics I've seen on researching it and my own 32 years of experience, 70, 80%.
Okay. Okay, and I did have a second question. Thank you for that. Use of force documents. Can you tell me where those lie? Are they like the body cam? They're
Separate, completely separate
Okay.
documents. They're their government records. All of that is, none of this is commingled. It's
Okay.
all separate.
Okay. Thank you very much.
All right, Representative McLaughlin.
So I want to go back, and this is more of a statement than that, but it's been brought up that mayors should do the investigation and so forth. I was the mayor of Uvalde for 10 years.
Yes, sir.
I'm not qualified to do an investigation. I'm not law enforcement and so forth. I will say, though, that we did get complaints on officers, and I did require an investigation. It resulted in 3 officers losing their jobs.
Yes, sir.
We also had investigations where the officers didn't lose their jobs. But it's not mayors or civil people, because they don't understand the law enforcement world, that should be doing this investigation. And like you said, I don't think we have enough people that could fill those committees to do that.
Yes, sir. And just from my background as a former Texas Ranger, one of the jobs the Rangers provide the state of Texas in rural Texas is that public corruption, public investigation, public integrity role. When you have that one-person agency or that two-person agency and that complaint comes forward, there is a law enforcement body that can be independent and come in and do that when that need arises. Yes, sir.
I was just going to ask that, so I'm glad you mentioned it. Members, any other questions? All righty. Mr. Hearn, thank you for being here. Chair calls Jennifer Szymanski. Show you registered as Jennifer Szymanski, testifying on behalf of Combined Law Enforcement Associations of Texas and for the bill. Is that correct?
That's correct.
All right,
I'm Jennifer
proceed.
Szymanski. Thank you for having me today, Chairman and members of the committee. I'm the Deputy Executive Director for CLEAT, which is the Combined Law Enforcement Associations of Texas. We represent 28,000 law enforcement officers across the state. I took a lot of notes because I don't want to repeat what's already been said, but I did want to clear up a few things, and I'm happy to answer questions. I think everyone understands now how we got to this language. I did serve on the committee that helped draft this model policy that we were asked to draft by the legislature. The commissioners voted for these policies after 6 months of working on those with a committee of stakeholders, sworn and non-sworn. I've been a sworn peace officer for 18 years, worked for the Attorney General's office, worked for the Austin Police Department, and then came over to work for CLEAT. With that perspective, I want to address some of the false narratives surrounding this bill and circulating the building. This is the prime example of why this legislation is needed. These same groups are the ones who seek to vilify law enforcement and smear officers ahead of any sort of due process. Too many stand ready to try an officer in the court of public opinion every opportunity they get. This negatively impacts the profession and law enforcement's relationship with the communities they serve. Going over a few of the things that were said. It was said that things like 911 calls, body camera, all these things, these are not part of the personnel file. Personnel files are only materials that are pertinent to, and it says it in the bill, to the officer or the license holder. Not 911 call logs, not body-worn camera. Those are not attached to the officer. So all those documents, and I think that was mentioned, are completely separate from this bill. One of the things that was said by the Dallas lieutenant made a really good point about the days off, that this could be used potentially against officers in their personal lives, which is a great point. However, another point there on days off, the early warning system that Dallas is wanting to implement and that all the other large progressive cities already have in place. We had it at the Austin Police Department. They have it in San Antonio, Houston. We have these early warning systems. Dallas can't have it right now because this would all be open to the public. And another trigger for those algorithms that identify the officers and the programs are days off. And another instance when days off sometimes can be alarming for a supervisor is if they are taken in conjunction with use of force or things that might indicate that they're struggling with their mental health. These are reasons why this algorithm and these early warning systems cannot be made public ahead of the supervisors investigating, pushing it up to internal affairs or whoever it is that's going to investigate. I think Representative McLaughlin, your response on the smaller agencies, that's exactly right. The smaller agencies do investigate. They absolutely do investigate. They can utilize the Texas Rangers, they can utilize the Texas Attorney General's office, and they do. And those investigations are required, as you stated. Those are required investigations by TCOL that is in state law. After the TCOL sunset bill, it is absolutely required that every head of agency complete a misconduct investigation on every allegation. That is now in state law. So the accusation that those just aren't happening, there is now oversight because of the legislature that TCOL has over all those files. They get to review them and ensure that the investigation did in fact take place, that it was thorough, and that the proper remedy was executed. Going into the in-camera inspection, this we disagree. The in-camera inspection, the district attorneys mentioned, or the one district attorney representative that's here mentioned, they want the entire file for criminal investigations pertaining to an officer. Well, that's not due process. The way it currently works is they get an in-camera review, and that's the way it should be. For example, we have Officer Taylor in the city of Austin who was just convicted of deadly conduct for doing his job. Prior to that, the system worked perfectly, and it was fair. And what it was he was working under 143.089G as an Austin police officer. There was a criminal case, and the judge in the case got to review the file, the departmental file, and determine what in that file was going to be released to the defense, or to the state in this case, for discovery purposes. That's how it should be. That's due process. You don't just get everything, regardless of who you are. As far as the comments that were made by the Harris County group, by the way, Combined Law Enforcement Associations also represents half of the Harris County deputies, the other half, who support this bill. Meet and confer contracts do not have any bearing on in-camera review. So for example, if a city comes into this law, if this law passes and you're not a civil service city, or let's say you're a deputy, you're not going to have a meet and confer contract, but you are still going to get an in-camera review in the event that there's a criminal case and a judge presiding over that criminal case. So we disagree on the meet and confer, that you need to have some kind of agreement to be entitled to that in-camera review. That's false. And we know because we represent officers on a regular basis who do work under these protections currently. The fact of the matter is police officers and the sensitivity of what they deal with daily should be handled the same regardless of which agency they work for. And that's exactly what this bill accomplishes. I'm happy to answer any questions if anyone has any.
Representative Pearson.
Thank you. Thank you, Ms. Mansky, for being here. I was actually hoping you were going to be here today. When the chairman laid out the bill, I asked the question, does this apply to every agency across the state? But I was hoping you were here because I specifically wanted to ask about Austin. The city of Austin does its own thing when it comes to police officers. And so what I want to know, if this bill passes, does this protect the officers in the city of Austin? Or do we need to do something additional? Or what is the way you were on the committee, what do you think this bill will do for the city of Austin?
So while I was serving on the committee, hands down, without a question, this would be, Austin Police Department was already covered by this when I was on the committee, and this bill absolutely would cover them.
Okay.
However, I will say this, that was September, that was in the interim from the last legislative session. After that, right before we came into legislative session, knowing we were going to codify this model policy, the Austin Police Association went to the table meaning they went to the table with the city to initiate a meet and confer negotiation process. During that negotiation process, they made a deal. It's a back and forth negotiation. That's what negotiations are. And you can make deals. And they did. And they made a deal that is contrary to this. So the answer to your question from our perspective, and by the way, we still represent around 900 Austin police officers today, Cleat does. Our perspective is that when this bill passes, they still have a contract because they executed, they signed off on it, their members, a meet and confer contract that is in place today. So as you know from other laws, when you pass a law, it doesn't supersede an existing contract. So we do believe that there may have to be some litigation. We absolutely want them to be covered by this. We absolutely don't agree that they gave this provision up as part of their negotiations, but they have every right to do that, and that's what they chose to do. We will work hard to ensure that they do come under this. Eventually, when their contract is up, they will absolutely come into this. But right now, they have a contract that they're going to have to deal with, whether that's through litigation or whatever that might be. We're here to support them, but there is going to be, with those officers, a small issue regardless of what happens.
Okay, that's what I wanted to know.
Does that make sense?
Yes, thank
Okay.
you.
Yes, ma'am.
So would it be accurate to say that in a meet and confer, you could disclose more
You can.
than what is predicted, but not less?
Correct.
Right, okay.
Correct.
Representative Louderback.
Thank you, Jennifer, for your service and for representing Cleat the way you do. The on this meet and confer that y'all had with Austin, there's a lot of factors at play here, aren't there?
Yes.
There are many, many reasons why they agreed to the conditions of this deal. So when Representative Pearson brings a question that she did, I think this bill would help in that regard to get back on track in so many ways. If we can solidify where we're going and bring the clarity and the consistency of what we have, which I've got to repeat that because it's only with that consistency that we can hope to advance on this whole thing. If we're still going in different directions on here and parties are not protected under these things, under this consistent model, we're simply going to be in a state of chaos so many places. So I think that this bill will help with recruiting. I think it'll help with the systemic loss of personnel that several of these things haunt law enforcement for years, and they have substantially been used to deplete our ranks. And so there's very few agencies out here in Texas that are not short of employees as we hemorrhage veteran officers every day. So these are things that, would you agree, that would be very beneficial for the industry of law enforcement?
Absolutely. Unfortunately, and I can say this as a former Austin police officer, unfortunately, many times when we come to the legislature, every session since I've been with Cleat, we come here in an effort to, in some of our legislative package, to prevent things that are happening in Austin from happening anywhere else. And that's how we ended up here. So again, we want them to come under these. We know that they will eventually, and we hope it's sooner rather than later. But we absolutely, as the sheriff said, as Representative Lauterbach said, we absolutely do not want this to occur anywhere else.
Thank you.
Representative McLaughlin.
Thank you again for your service. And again, I'm not against law enforcement. I just want to make sure that we're not closing a door that shouldn't be closed.
Yes, sir.
But as outlined on this bill, subsection C, section 1701, 45351, I would specify that a department file must contain, and I quote, a letter, memorandum, or document relating to the license holder not included in a personnel file, including any of the three listed items regulated to alleged misconduct for which the agency determines there is insufficient evidence to sustain the charge of misconduct. What is the definition provided in statute of any of document?
Any document inside of a personnel file?
Or what is the definition provided in statute of a document, or what they're considering a document?
So it would be, as the chairman explained, it would be anything that is not in the personnel file, and those are listed specifically. So, but what I'm trying to get at, and what I was trying to get at earlier, is that that doesn't include a lot of the things that have been mentioned today that are more departmental wide, like body worn camera, 911 call logs, those things. Those are not included. I think what you're asking is what else might be in there, and I wanted to get into that. There are background investigations that are currently open to the public for agencies that are not 143. Now, are they redacted? Yes. But political subdivisions are constantly requesting opinions from the Attorney General's office, and in many cases then subsequently suing the Attorney General's office because it's simply not proper what we are required as a political subdivision to release for these at-will agencies. It's, for example, background investigations. Currently, I'm a city council member in a smaller city around here, so I have a different perspective as well on this, meaning I've seen the other side from the city side, as you have. It's disturbing what we are required to release on law enforcement officers and their families. Currently, the only thing that's redacted per the AG, and he's only going off of 552, is the PII, the personal identifying information. That's it. Everything else that we provide in our background investigations, which goes, as many know in this room, way in depth on our family members, any encounter that they've had or we've had with law enforcement. Many of the times we're okay with releasing things on the officer. It's on their backgrounds because we're proud of who we hired. We wouldn't have hired them if there was something in there. However, their family members, that information absolutely should not be released to the public. Another thing that's in there that hasn't been discussed today, I think I discussed it in the last committee hearing, are coaching reports. They're called counseling, they're called different things in different training memos, different things in different departments, but it's how we train officers. So it's supervisory notes, I think someone said earlier. Those are things that we need to be documenting, and we do. I was a patrol supervisor when I left APD. We do document those things. But in Austin, they're all protected unless it's a substantiated investigation. So we're talking about things that you do when you debrief a new officer on a call and you say, you need to do this better. These are some recommendations. All those things, we want law enforcement to document those. But this is a gray area here when supervisors, let's say in a sheriff's department, know that all that is going to be open to the public. Do you see where that's potentially an issue? I mean, you need to be able to document that knowing that it's confidential unless it rises to the level of an internal affairs substantiated misconduct.
And I would agree with you on that, keeping that confidential. And I do believe a background check, other than what pertinent information, be there any family information, should be redacted and never released, because so many of these officers have to deal with that today.
Yes, sir.
So I
Thank
do
you.
agree with you on that.
All right, members, any other questions? All righty, Jennifer, thank you for being here.
Thank you.
Is there anyone else wishing to testify on, for, or against Senate Bill 15? If not, okay, that'll end our public testimony. And then I will close on the bill. Members, again, this is a bill that will standardize and make consistent statewide practice regarding personnel files. I want to remind everyone there was an interim study that was authorized by this legislature last session. We instructed T-Cole to go out and come up with a model policy that would apply statewide to have a consistent statewide model. That was made up of prosecutors, defense attorneys, people from the public, police, and law enforcement officers. They went to urban areas, rural areas, large and small cities all across the state to come up with this. This wasn't just something that one certain group or somebody dreamed up. This was a working group that went all over the state and had lots of input. 26,000 police officers already operate under the provisions of this bill. T-Cole will still have access to these files, as well as any hiring agency that's looking at these officers. So with that, if there are no questions, I'll close. I know during the regular session, we typically leave these pending for a little bit of time, but I'm going to go ahead and take a vote on this bill and move it through the process if the votes are there. So with that, the chair moves that Senate Bill 15, without amendments, be reported favorably to the full House with a recommendation that it do pass and be printed. The clerk will call the roll.
Chairman Hefner,
Aye.
Vice Chair Lopez,
Nay.
Canales, Cortez, Isaac, Durazio, Lauterbach, McLaughlin,
Can I make a statement as a vote?
Sure.
I just want to say to the public that I don't want to vote for a bill that gives any law enforcement agency authority, whether directly or indirectly, to hide files related to a mass casualty. Excuse me. If this bill allows that anyway, I would be voting no on the floor. However, I will vote yes to take it out of committee.
Representative Holt. Yes. Representative Pearson. Aye. Representative Hicklin.
There being 7 ayes and 1 nay, the motion prevails. Members, is there any other statements or comments y'd like to make? Where's my closing stuff? All right, if not, members, that includes today's agenda. Is there any further business for the committee to address? If not, the chair moves to adjourn. Is there objection? Hearing none, the committee stands adjourned, subject to call of the chair.